Hello. I get a lot of questions from potential clients and clients about what the requirements are for maintaining employment records in California. So, this short video will go over some of the basics. So there are several types of records that employers maintain on their employees. The first are typically maintained in personnel files, and that would include application and new hire materials, payroll authorization forms, commendations, disciplinary documents or termination documents, any notices of furloughs or employee leaves of absence or vacations, wage attachments and garnishments that you may have to process for your employees, education and training records, performance reviews, and attendance records. In addition to those standard personnel file documents, employers also often receive medical records or medical documentation relating to their employees. This could be medical records that you receive in response to an employee injury or an employee who has to take a leave of absence due to a medical condition. Could also involve medical records that were obtained during the interactive process that you engaged in to accommodate an employee with a disability. And also, you'll typically have time records, time cl- time clock records, punch records, employee timesheets, that kind of thing that is often kept separate. So, one of the threshold issues to discuss with regard to employee personnel documents is access to those documents. Access should be limited to those with a legitimate business need to see the information. For example, with e-health information, perhaps there's someone that coordinates the interactive process or the leave of absence process for your employees, and they would only need to access those records. Perhaps the supervisor is engaged in that process in determining whether an accommodation can be provided for this employee. In that instance, they may also have a legitimate need to see employee health information. Employees also have rights under the Labor Code to access their information in their personnel file and their payroll records. If you get such a request, there are specific timeframes that you have to meet. And then when we're talking about access, we need to also talk about security, both for electronic and hard copy records. They should be locked up or they should be password protected, etc. Now we'll go through each of the different types of records and how long they need to be maintained. So this slide here is recruitment, hiring, and job placement records. The retention period recommended for those is 3 or more years. And that's because that's the statute of limitations for legal claims that could arise for these type of records or the period of time that you may be subject to an audit for these types of records. So job applications and resumes, referral records, job postings and ads to establish the criteria that you were looking for in employees, employment testing results, salary information, terms and conditions of employment, and if you have uh, minors who are employees, child labor certificates and notices. Also, just a note here, I-9 forms have to be maintained for 3 years from hire or 1 year after termination, whichever is longer. Wage and payroll records have a retention period of 4 years or more. The recommendation here pertains to time cards, wage calculation tables, shift schedules, piece rate pay, any employment contracts that you may have that set the rate of pay, and the employee pay stub. So a claim for unpaid wages, for example, can potentially go back 4 years, depending upon how the employee brings that claim. And so you want to maintain not only these records and the payroll records that are in your payroll system, but also an actual copy of the pay stub that the employees receive. For leave of absence records, the retention period is 3 years. This would include leave policies and benefit policies, dates and hours of leave used or requested, records relating to any disputes or conflicts or questions proposed by the employee relating to a leave of absence, benefits relating to the leave of absence as well, such as medical benefits that were maintained or seniority records. With regard to employee health records, the records retention period is typically 3 years. This is typically related to Cal OSHA requirements. For example, first aid for job injuries that caused a loss of work time. Also, this would include drug and alcohol test results, and also our new laws pertaining to notices and records of COVID-19 cases must be maintained for 3 years. There is a note here that chemical safety and toxic exposure records have to be kept for much, much longer. That would be the duration of employment plus 30 years. Benefits data should be maintained for 6 years, but not less than 1 year following a plan termination. This would include benefit selections made by an employee, beneficiary designations, eligibility determinations, any COBRA notices that you sent or received, and summary plan descriptions and earnings. Another note here, the records that are required to determine the amount of retirement benefit an employee is entitled to should be kept indefinitely. And then just a last note here, if you receive a claim or legal documents from an employee initiating a lawsuit, for example, the records relating to that employee and that claim need to be kept until the case is completely closed. That may be after the appeal period has run, for example, you would want to consult your attorney, but this would include any personnel and payroll records pertaining to that employee, any emails or other correspondence with the employee or amongst other employees about that worker, and potentially employee work product, and sometimes other documents such as calendars and other items pertaining to this person's employment. You'll want to consult your counsel with regard to what types of documents should be kept, but those need to be kept through the end of the case. And that would include overriding any automatic document deletion that you have, such as emails that are deleted after 1 year from the server, for example. So, and statute of limitations for a FEHA claim for sexual harassment, for example, must be filed with the administrative agency in 3 years from the date of the incident typically. And so they have 3 years to file. If they file on the very last day, that's getting to the end of the recommended records retention period. But you would want to keep those records longer if you do have a dispute with that employee or a claim from that employee until your attorney advises that it's safe to dispose of those records. I hope this was helpful. Thank you very much.